Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court will draw near to their attendance and shall be heard.
Thank you. Please be seated. Before we begin our calendar today, we have 11 candidates who will be sworn in this morning as attorneys and counselors at law, together with their families and friends who are here to celebrate this achievement with them. As a point of personal privilege, I would like to recognize one of these candidates, Leah Ann Higgins, my niece and godchild, together with Leah's mom, Anne Marie Kelly, who's here, Kevin Kelly, her stepdad, and Tim Higgins, her father. Welcome, family, and welcome to all. And Ann Dillon Flynn, the clerk of the court, will administer the oath. Ms. Dillon Flynn, have these candidates been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by an attorney and counselor at law?
Yes, they have.
Please administer the oath of office.
I do solemnly swear.
I do solemnly swear
That I will support the Constitution of the United States.
that I will support the Constitution of the United States
And the Constitution of the State of New York.
and the Constitution of the State of New York,
And that I will faithfully discharge.
and that I will faithfully discharge
The duties of an attorney and counselor at law.
the duties of an attorney and counselor at law
According to the best of my ability.
according to the best of my abilities.
Congratulations.
A career in the law is very often driven by the desire to be in a position to help people. People who are very often at desperate points at times in their lives. People who feel like there's no way to get through it, there's nowhere to turn. You, as attorneys and counselors at law, will be often the person they turn to. It's an extraordinary gift to be able to help people in such a way, to play such an important role in the lives of our clients. I wish you all great success, and I'm confident that in the years ahead, you will find great fulfillment, great accomplishment, and great satisfaction. Congratulations, and have a great rest of the day. We'll wait a minute before we turn to our business, which is the calling of the first case for argument. Oh, sorry. Okay, the first case on for argument today is case 1031, People versus Carino.
Sorry, Your Honor, did you say Curio?
I mispronounced it, my apologies to both you and your client.
I'm actually here on behalf of the people, Your Honor.
Ah, very good, yes.
May it please the court,
Yeah,
Mackenzie.
I guess the appellant submitted, right?
Yes.
Very good, proceed.
May it please the court, Mackenzie Stutzman on behalf of the people of the state of New York, respondent. I'll be very brief because there's only one question presented by this appeal. It's the applicability or non-applicability of penal law section 70.25 subdivision 3. And as this court has previously held, the test is the divisibility of the defendant's criminal conduct in this application of this statute. In this case, we have clearly divisible criminal conduct occurring at two separate times over the course of one evening. There's a distinct break. It's not continuing conduct. And as appellant has urged, the test is not divisibility of ancillary conduct outside of the criminal
Well,
conduct.
there's the initial conduct, and then there's a period of time where the defendant is asleep,
Yes.
and then he wakes up, and then there's different conduct.
Yes, correct, Your Honor.
And so you're saying that separation leaves us not being, not falling into the category of a single incident or transaction.
Correct, Your Honor.
I think we understand that argument.
And if there are no other questions, I will yield the rest of my time.
Thank you.
Thank you very much.
Case 1032, People versus King. Proceed, counsel.
Good morning, Your Honors. May it please the Court, Thomas Leaf for Mr. Shamik King. Today I'd like to address points 1 and 2 of the appellant's brief, largely focused on the sufficiency and weight regarding count 2 of the indictment. And it's our position that the people did not prove beyond a reasonable doubt that there was proof of anal sexual conduct sufficient to find Mr. King guilty of count 2, and that there was no proof of penis to anus contact. The sole proof that the people could muster on this was testimony by the complainant that she felt him try to enter her rectally. Now we know it's our position that that's a rather thin branch to hang this conviction on and this 25-year extra sentence on. So, for example, there was certainly no physical proof. There was no forensic proof of any contact here. That was confirmed by the sexual assault nurse examiner, who found that the.
Are we trying to determine whether it was a fair inference for the jury to determine, based upon the evidence that you've just mentioned, that the contact was with maybe a finger as opposed to a penis? That's what you're saying?
Perhaps a finger as opposed to a penis. Perhaps felt him try could mean that she felt some part of her body touch that was not her anus, perhaps her buttocks. These things are completely ambiguous in terms of the actual element of penis to anus contact, which is the entirety of count 2 of the indictment.
But wasn't there a small laceration to the posterior fourchette area, which is very, very close to the anus?
Well, that's the bottom part. That's where the
Yes.
labia minora meets.
Right.
But my understanding is that certainly there was no testimony that one could get an injury there based on anal penetration. And I think that is part of the vulva. That is part of the body that is separated by the perineum there. And it's not the type of injury I would submit, and certainly there was no testimony that it could be, the type of injury that could result from penetration to the anus. And besides, she did not even think that it had occurred. She thought it had not.
But didn't the nurse testify that it could have been, or it was close? The sexual assault nurse, didn't she testify that that was close to that area?
Well, it's close in that all those things are close there, Your Honor. I don't believe that there was any testimony saying that this could have resulted from any kind of anal penetration, Your Honor.
Well, the way that the people look at it is that in context, the victim was testifying as to what was happening immediately prior to this attempt. And there was beating of the victim by the defendant with his hands. And then she testified, he then flipped me over and so forth. And the way they look at it is that it's fair to assume that she, because I agree with you. I mean, it would have been helpful if she specified what part of his body came into contact with her anus. But they say it's reasonably inferable from the context of her overall testimony that it had to have been his penis. His hands were, he was busy doing other things with his hands at the time. That's the way they look at it. I guess your point is, if you're going to convict someone, give them 25 years, we need specificity?
Certainly, Your Honor, and I think I know what you're referring to in Respondent's brief. I think that there's no clear picture as to where his hands were, whether or not this was one hand was holding her down. This is apparently a strong man. There's no clear picture as to when these things might have happened. So I don't think from...
As I understand your argument, it's really that it's not as if and you correct me if I'm wrong, it's not as if the evidence was there, they just didn't ask the questions. You point to the fact that the victim appears equivocal about whether it even happened. And so your jumping off point is there. You're saying, look, even the victim is saying, not sure it even happened. And so therefore, any evidence that flowed from there, it falls into that kind of ambiguous category.
Your Honor, I think that's right. And so she says, so the question that was posed to the victim in this case was, did he enter you anally a little bit? And she says, I didn't think so. But then the presence of a laceration, which we're submitting is a mistaken belief on her part, a presence of a laceration to her anus made her think that, quote, something must have happened.
Right, but I think the way I read her testimony was that she was under the misapprehension that there had to be penetration. And the question was, did he enter your anus? Of course, for this crime, there doesn't have to be penetration like there is for rape, just contact alone. So I think in the context of what you're talking about, she meant, did it happen, was there penetration? She wouldn't know, I don't think she knew what the elements of the crime were.
That's a fair point, Your Honor. But I don't think that we can take anything from that statement, one way or the other. And then the only other statement she gives is, I felt him try. And our point is that, as Justice Whalen pointed out, this could be contact with some other part of his body.
If she testified, I felt him trying with his penis, then it's a different story, right?
It's a different story, though. We still have to know that that there was contact with the anus being made. I mean, and this is an inaccessible part of the body. It's not a given that he would have succeeded in that contact. And I think
let me just, the question before that was, and when he flipped you over, did you feel him trying to enter you anally? And she said, I felt him try, yes. If she said, I felt him try with his penis, yes, then obviously that's penis to anus contact.
it's closer. Maybe his penis merely touched her buttocks. I think it would be a fair inference by her to think that this was part of the trying. And I think this all could have, this is something you referred to, Justice Whalen. This could have been cleared up. This could have been cleared up with a simple question by the prosecutor. What do you mean by try? What body part did you feel touched? What body part do you think touched you from the defendant? And that question was not asked, and it's the prosecution's burden in this case. And this is an experienced prosecutor. Now, whether that was a mistake or whether that he was concerned about what the answer might be, they did not sustain their burden on this point.
Even if you're right on this point, your client's still looking at 25 on the rape.
He's still looking at 25 on the rape. The rape itself has not been challenged. And I think that there are other parts, if there are no further questions on point one, just briefly talk about point two. There were 3 comments by the prosecutor on this case that unequivocally said he penetrated her anally, and that is just in contradiction of this complainant's testimony. And it's our position that this was particularly important because the state's proof was incredibly weak on this very important point. And you had a prosecutor say something that clearly is not, it's a mistake, in our view, it's a mischaracterization of the testimony. It's not a clear inference from the proof. And you had this is the kind of case that's inflammatory, it's upsetting for juries, and it was important both that the prosecutor stick to the 4 corners of the inferable evidence and that there was no objection by the defense attorney, that's true. And we would ask that you consider it in the interest of justice. And also importantly, I think it's the kind of situation where this court, as a 13th juror, the role here, this is what the weight of the evidence review is really all about, because this court is in a better position to not be swayed by prosecutorial remarks that overstep the line, and also will not be swayed perhaps by the nature of the case itself.
We'll take a look at that, counsel.
Thank you, Your Honor.
Thank you.
May it please the court, Elizabeth Denman for the people. Your Honors, we would just submit that he tried to enter me rectally is not an ambiguous statement. It shows that there was contact. There was
Contact between what?
penis and anus. He was holding her down with his hands. It was a few-minute encounter. She clearly stated he was holding her head down with a pillow, and then he flipped her over and tried to enter her in the same way as they've been speaking about entering her with his penis vaginally for the remainder of.
Don't you, when you read the transcript, doesn't it jump out at you that there was a question that was lacking that needed to be asked by the prosecutor? What part of his body came into contact with Uranus? I mean, just, I think,
Well, Your Honor, it did appear from the whole context that the entering was in the context of his penis. It seemed to be very plainly the context. So it did not, to my reading of it, need to be reiterated.
So your point is, look at the transcript, and it's a fair inference that his hands were otherwise occupied, it couldn't be his hands, and it therefore had to be his penis, and you want us to take a look at the transcript to see if we agree with that.
Yes, Your Honor. It's been speaking about entering her vaginally for, and obviously in the context of her, with his penis for the prior part of her testimony, Your Honor.
Very good. Anything further?
No, Your Honor.
Thank you, Counsel. Case 1033, People versus Van Woehouse. My apologies if I've gotten that wrong. I'm batting 0 so far.
Good morning. May it please the court, Dave Jurgens for Mr. Van Woehouse.
Woehouse, thank you.
I'd like to address points 1 and 5. Under point 1, the trial court should have granted a mistrial. The prosecutor clearly violated the court's Molyneux ruling, asking an open-ended question on redirect that elicited severely prejudicial testimony about a prior alleged incident of strangulation. And I think the context is important.
Counsel, let me ask you this. So let's just assume for the sake of argument that it was improper, it was on redirect. It's an improper question. Let's assume it elicited a violation of the Molyneux, right, ruling. What was the court, at that point, what was the proper step that you think the court should have taken? Because the court in this case sustained, I think, and correct me if I'm wrong on the record, sustained the objection. The testimony was stricken, and there's a curative instruction which the jury is presumed to have followed. So are you arguing that there was no steps that the court in its discretion could have used once that was done on redirect and once that evidence was before the jury, the bell had rung, you can't unring a bell? Is that what you're arguing?
This is one of those rare cases where we can't expect a jury to follow that instruction. This was such a visceral image that the jury was given of a male strangling the mother in front of her children. I mean, that is such a danger that they're going to convict the defendant for no other reason that they perceive him as a bad person. And I think the context is important because on direct examination, the prosecutor started going into the relationship before 2019, which was the time frame of the indictment. And there was a Molyneux objection. The court sustained it. So the people were on notice. Then they started asking questions about 2018 letters that were outside the time period of the indictment. On cross-examination, defense counsel didn't ask any questions about the prior relationship. He did clarify that the witness, when she was talking about these prior letters, that there was no prior letters in 2019. It was just the 4 ones that were the counts of the indictment. And then he asked about the delay in reporting. The first 3 letters, there was a significant period of delay before she went to the police. And he tried to suggest that maybe it was because she got served with a family court petition that was the reason for the delay. And she answered no. I gave those letters immediately to my family court attorney. It was just mere coincidence that the charges were filed after the petition. Said nothing about being afraid of Mr. Van Woehouse.
How many other contempt or orders of protection were given in this instance against this individual?
Well, he had prior orders of protection, and it's clear from the evidence that he knew that sending the letters was a violation of the order of protection. And I addressed, I think it was in point 3, where there's...
Very overwhelming then? I mean, you got 4 letters here. He's aware of the fact that this is a number 1 stay-away order of protection, that the individual, by sending a letter or any communication, is a violation.
I think that there's overwhelming evidence that he knew that he was violating the order of protection. I think there was an argument that could have been made in summation that wasn't made, that there's a distinction between doing something knowingly and doing it intentionally such that your conscious aim or objective is to violate the order of protection. His conscious aim and objective here, from the overarching themes in these letters, was to have contact with his son. He was begging for the complainant to let him see his son. The people cite a case which I think is actually good to make this distinction. They cite this case in their brief, People v. Lynch, U.S. v. Lynch, and that was a case where there was abortion protesters that wanted to block access to an abortion clinic. And the order was, you're not allowed to block access. They went ahead and did it anyway. They were acquitted, and there's the issue on appeal was whether it was double jeopardy, but my main point is that this order that Mr. Van Wickhouse violated was not directed to prevent him from having contact with his son, okay? That was his conscious aim and objective.
The only contact that he could have with his son was if it was subsequent to a later order of another court.
Right, and there was a provision in the order.
There's a means for him to contact his son by getting a separate order from another court saying that it's permissible, rather than this method of sending letters to the protected party.
That's correct, and I guess my point is that under point 1, we don't even have to get to harmless error because the prejudice was so severe and egregious that it was a denial of Mr.
Well, your argument is that he is attempting to contact his son. That's my intent to do this, but there was another method of doing that he most likely was aware of. I need a subsequent order.
And I don't disagree that what he did here he shouldn't have done. It violated some criminal provision, but I guess the point is that the mistrial here should have been granted because the testimony about this prior unlitigated incident of strangulation was not a predicate for any of these orders of protections. That charge was withdrawn and dismissed when he pled to a misdemeanor.
Right. Can I just ask you this? One of the factors that we look at in whether on appeal to grant a new trial, you say the option you argued that the trial court should have granted a mistrial, that a curative wasn't enough.
Additional factors would be this was a very short trial. This is a one-witness case. They could have started picking the jury.
One key factor is, did the prosecutor intend to elicit this improper testimony?
And
if so, that augurs for a mistrial. If the prosecutor intentionally asked the question to get information that shouldn't have come out. Here, it's a little unclear. The prosecutor looks like he said, what happened after you broke up? What started happening after you broke up?
Well,
and then the woman said, I was harassed, stalked, and physically harmed.
And the prosecutor should have expected that. The prosecutor knew or should have known that this was testimony that was precluded by an order.
Was it all, or was it just the strangulation?
The strangulation is what prompted the mistrial. That was the image to the jury.
But the rest of it, I was harassed and stalked, that is admissible, right? So, I mean, in other words, I'm just giving the prosecutor the benefit of the doubt, maybe unfairly so, but it's not 100% clear to me that he knew by asking that question he was going to get strangulation as an answer. And that's kind of a factor we look at. But and you've argued that one very thoroughly. On issue 5, with respect to the sentence, do I read it right that prior to trial on 4 felony counts, he was offered a misdemeanor with probation?
Yes, and he should have taken that offer.
And then he gets indicted, and prior to trial, they offer him 1.5 to 3.
Yes. And
his letters were, the way I read them, they're love letters to his son. There's some inappropriate sexual material in there for the mother, but by and large, this man was despondent that he was missing time with his son. Wanted to go fishing, these things. He was begging to have a relationship. There were no threats of violence. He was desperate. He was in jail. He wanted to see his son. Your point is that, and by the way, if he didn't have a record, these would just be misdemeanors and it would be capped at 2 years.
Yes.
So he goes from a misdemeanor with probation and he ends up with 4 to 8. In your view, that's just too much of a disparity.
Absolutely.
I think we have your argument, counsel.
Good morning. Marty McCarthy for the People. I'm actually going to start at the end since that was something you were interested in. Something to bear in mind in this case is something the court may not be aware of. After the defendant's prior appeal, the one that the defendant relies on with respect to his weight of the evidence argument, in which the court reversed his plea to the aggravated felony offense and sent that back for a trial. That case did go to trial. That case went to trial during the pendency of this appeal. He did not accept a plea in that case, and he was convicted in that case as well, and he was sentenced in that case.
What did he get on that?
I think it was 2 to 4, but if you look at the doc's calculation of a sentence, they somehow have a sentence calculated as being 4 to 6 years. So I can't really explain how docs use his sentence at this point. So in that sense, I can't, in terms of arguing whether the sentence was harsh and excessive based on the fact he got 4 to 8, docs is calculating his sentence differently. So I'm not entirely sure with respect to how docs use what his sentence, his minimum and maximum is, based on the calculation of the 2 commitment orders. But the court should be aware of the fact that he refused to plead guilty on that case as well. So this is not...
Regardless, he's got 2 other contempt convictions, correct?
Yes. Yeah, so he's a serial violator of court orders. That's what he is. And in this sense, with this case and with that case that I just referred to, he refuses to accept responsibility.
Right.
The court should really consider that.
He is a serial violator of court orders, and that's a tough fact to get around. But in the world of serial violators of court orders, I would suggest that perhaps he's on the less dangerous side. I mean, he's just writing letters.
Just to be clear, though, it's the same victim in both cases. Just to make this clear.
No, I understand, but there's no threats. He's not going, we see a lot of criminal contempt where they go to somebody's house and they're trying to get at him and so forth. The guy's writing letters, again, against the law. This is why he got a felony, by the way, so.
Well, he was also, the other thing to remember is he couldn't go to her house because he was incarcerated. So, in that point, he'd been incapacitated from personally violating the court order. So, I mean, the court should look at the means as well. Going back to if there's no other questions about point 5, I'll go back to point 1. Here, you have to look at, one of the factors that you have to look at is whether the prosecutor intentionally asked that question. And I don't believe the prosecutor intentionally asked that open-ended question to elicit that particular response, that single isolated word that the defendant relies on to justify a mistrial. And the other thing that happened is what the defendant described on appeal, and the argument to this court was, in essence, he was using the Malino ruling as a sword. Or you weren't, there was a delay and you reporting this to the police. Well, why was there a delay? In a sense, why was there a delay? Well, the prior history between these people becomes relevant the moment the defendant asks that question. He used the Malino ruling as a sword, and that's what the people believed in arguing against the mistrial, that, yeah, he opened the door to that. The court disagreed, and I'm bound by the fact the court disagreed, but this court should take that into consideration as to whether that question was intentionally asked. And I submit that it wasn't. The court took prompt action, sustaining the objection, striking the testimony, and issuing the strong curative that the jury is presumed to have followed. And if there are no other questions?
No questions, counsel. Thank you.
Okay, thank you.
Case 1034, People versus Jones. Proceed, counsel.
Thank you. May it please the court, Scott Porter on behalf of Pierre Jones, and I'm going to focus my attention on the points I raised in my reply brief, points 1 and 2, and the sentencing point. Anyone who reads this record can appreciate and be sensitive to the challenge that faced the trial judge in this case. And it's also fair to say that when Judge Miller decided to have a conversation with the two attorneys in this case outside of Mr. Jones' presence, that it was for the purpose of a candid and frank discussion about my client's pro se motion to the court for new lead counsel, as well as an adjournment of his trial, which was a week away. And all this transpired in the pretrial conference a week before the trial. The frank and candid nature was fruitful. Judge Miller pretty much decided that in light of the circumstances of this case, that it would be best that lead counsel not be in the courtroom during the trial, and that second chair would represent Mr. Jones at the trial.
Right, so your argument is on that February 7th, 2021 appearance when the court excused your client, that was improper. He should have been in there to hear Mr. Young say what he had to say. The counter argument is that your client got what he wanted. He wasn't there. He came back. He was there he got to be heard on it. And the court ultimately granted him what he wanted. He wanted Mr. Keller off. And the court put Mr. Keller off the case. So the people say, even if he was improperly excluded, A, he got a chance to be heard before the court made a decision, and he got what he wanted.
I have two responses to that. The first is that Mr. Jones also wanted an adjournment. And we don't know if he wanted Mr. Young to be his attorney. We know he wanted Mr. Keller off, and he got that. Ironically, that was never explained to him in the courtroom when he was allowed to be present, because he left on his own accord about probably 5-10 minutes later. Judge Miller never had the chance to tell Mr. Jones, by the way, this is where things stand as of now. And history repeated itself a week later when Mr. Jones made the same allegations about Mr. Young that he had made about Mr. Keller.
I think Young was his sixth lawyer. He threatened to kill his third one. He was unhappy with one of them got recused, but he was unhappy with everybody and wanted to kill one of them. So it's a tough situation of what do you do as a trial judge when you have a client there who's never seemingly going to be happy with anyone who's representing them. The trial has to go forward at some point, and that was the situation that was presented to the trial judge.
And here's the nub of my argument. Had Judge Miller had Mr. Jones present when this transpired and told Mr. Jones that I'm going to deny your requests, I would not be raising that on appeal. In fact, I'm not raising the collateral issues as it relates to what we're discussing as part of the brief. The problem is that when Mr. Jones was absent, Judge Miller asked second chair, the witness to the allegations made by Mr. Jones in his pro se affidavit, do you believe this in any way? And Mr. Young said no. And we know when there's challenges to an attorney's ineffectiveness that the attorney has the right to respond because the door is open. But Mr. Jones's focus was not on Mr. Young's performance, it was on Mr. Keller's. And
Look, that's a fair point, but Mr. Young did support your client's position. He said there's a breakdown in the relationship between Keller and the defendant, and he supported the relief requested by the defendant. So he didn't take a position contrary. He did contradict him on some things, but ultimately he said, I agree with the defendant that this relationship has broken down, and he should be removed from the case.
But Mr. Young also disagreed with the allegations as it related to Mr. Keller's not sharing discovery with the defendant, not bringing a motion that the defendant wanted to be brought. And I view this as falling within that window of cases where defense counsel is disparaging the position advanced by the defendant. And unbeknownst to Mr. Jones, there was an actual conflict of interest. And that's why it's unfortunate that this gap was created in terms of him being excluded. He was not aware of any of this. And so when he asked Judge Miller, before jury selection started, that he wanted Mr. Young to be relieved. He didn't know about Mr. Young's comments in his absence, and frankly, I don't think that conversation would have happened. That candid conversation would have happened in Mr. Jones's presence. And what we have is a record that shows a counsel in the case taking a position adverse to the position that his client pursued a week before trial, and that his client never knew about.
We'll take a further look at that, counsel. Anything?
I did want to mention briefly the sentencing point. Mr. Jones was absolutely clear when he walked into that courtroom that Mr. Young no longer represented him. In fact, he had fired him before the trial started. And I submit that the court should have inquired of Mr. Young whether he intended to represent himself at sentencing. And that was never on the plate. And if this court affirms Mr. Jones's conviction, I submit that it should vacate sentencing and remand for the purpose of ascertaining whether he intends to represent himself at the sentencing.
We'll take a look at that. Thank you, counsel.
May it please the court, Elizabeth Dannon for the people. I would like to first address the first issue that Mr. Porter raised about the discussion outside of the defendant's presence. It is well known, it is established precedent that although an attorney is not obligated to comment on a client's pro se motions, he may address allegations of ineffectiveness when asked to by the court and should be afforded the opportunity to explain his performance, and that is not considered adverse, and that is exactly what...
Right, well, that's in the context. What Mr. Young is arguing here is that the problem was the court excluded the defendant. They were all in court, and then he said, okay, you go outside the courtroom. That was the problem here. I said Mr. Young is Mr. Porter, I'm sorry. That the problem here was, the main problem was the defendant was kicked out of the courtroom when they were going to discuss his application. Like, why, what was the rationale there?
There was obviously a very volatile relationship between the defendant and the counsel and the judge. The counsel had been, the defendant had been violent and had to be removed from the courtroom many times. So the court was endeavoring to deal with a situation that was unprecedented in the best way it could. And they did, I would submit to the court that they cured any prejudice that he suffered by inviting the defendant back into the courtroom to be heard on the matter as well. So he was afforded a full and fair opportunity to be heard, which there's also...
Well, he not only was invited back and given the opportunity, he took advantage of the opportunity.
He did. He fully aired his concerns and grievances. Yes, Your Honor.
And he got the relief he was seeking primarily, right?
Both the relieved counsel and Young both advocated that the relationship had broken down, and so they both supported a new counsel being appointed. And we should point out as well that the defendant had lauded Young's performance. He had said he was very expert. He said he had been spent a long time, had heard him fully. He was very satisfied with his performance. So the court was aware that there was a good relationship.
Didn't last long.
What's that?
Didn't last long thereafter.
No, as soon as he was the first chair, it apparently broke down. Yes, Your Honor. And in terms of the sentencing, Your Honor, we would just say that that issue is precluded because the defendant was unruly. He refused to. He was repeatedly told by the court to stop interrupting, and he would have his turn to be heard. He refused. He yelled, and he was removed prior to his opportunity to be heard, rightly as per precedent.
Thank you, counsel.
Thank you, Your Honor.
Case 1035, People versus Lee. I believe Counsel Mayer is going to be appearing by video, so we'll give counsel a minute to hop up online here.
There you go.
Counsel, can you hear us? You're on mute, so let's unmute it just so we know we can hear you and we have a good connection.
Sorry about that. Yes, I can hear you.
No problem. Very good. Thank you, counsel. Please proceed.
Good morning. May it please the court, Ken Tyler for Mr. Lee. One of my great hobby horses is belaboring my points in the written brief, and I think I did a marvelous job of that in this case. So I'm hesitant to do that again here at argument. As the court is aware, our point one is multiple evidentiary errors impacted the fairness of the trial. Our point two is weight of the evidence. With respect to the menacing first conviction, the district attorney has conceded that conviction's against the weight of the evidence, among a couple other concessions, which I appreciate the candor in that. Our weight claim is primarily focused on, with respect to the weapons, the lack of any evidence tying the firearm found outside the residence to Mr. Lee. That would result in dismissal of the indictment. Obviously, our point one, our evidentiary arguments would result in reversal in a new trial. If there's any particular questions I can answer about either of those points.
I have one question on one of your points. Not a lot turns on it because you got concurrent time, but your client was convicted of criminal possession of a weapon third and criminal possession of a firearm.
Correct.
CPW third is a D felony. Possession of a firearm is an E felony, so it's a lesser.
Right.
You argue we should dismiss criminal possession of a firearm as a lesser conclusory offense of CPW.
Correct.
Is it your understanding, do you believe that they're lesser included offenses, which is a separate issue?
I believe the criminal possession of a firearm is a lesser included offense of the CPW, and I believe I've cited cases that treat it that way.
A lesser included offense is one where you can't commit the greater without committing the lesser, right?
Correct.
But here, CPW third, the provision he was charged under says you're convicted of it if you commit CPW 4 and you have a crime on your record.
Right.
CPW 4 is defined, it's a misdemeanor. You commit that crime by possessing a firearm and a million other things, half of which I'd never heard of.
Mm-hmm.
Starfish, all these weapons.
Mm-hmm.
So isn't it possible to possess a starfish or a kung fu triangle, whatever they call them? That's, if you have a prior crime, that's CPW 3. But if you have a gun, it's not criminal possession of a firearm, right?
No, I guess that's a fair point. If your underlying CPW conviction, looking back through the third to get to the fourth, I guess if the underlying conviction, that's a fair point.
So do we look at the facts of this case, or do we look at it in the abstract like Glover tells us?
My argument, obviously, would be to look at it in the abstract. You couldn't have gotten to...
Well, that's not really your argument.
I'm sorry?
Right? Your argument is that not that it's a lesser included offense, but it's a concurrent inclusory count.
It's a lesser inclusory, correct.
There's the point you're making, those are two different. I mean, Justice Lindley is explaining that if you look at it from the abstract, it may not be a lesser included offense.
That's true. I misunderstood. My argument is limited to specifically the context of...
Both convictions deal with his possession of that particular gun found in the brown bag.
Correct.
Not any of these other weapons that he...
Not any other weapon, not any other abstract fact. It's purely the analysis within the lesser inclusory realm of whether a jury should be considering that next...
Well, really, what is under, I think, CPL 330, that lesser count, the concurrent count, should have been dismissed.
It's deemed dismissed.
After the conviction. You have to look at the conviction.
After the count that's considered preceding it. And to your point, Justice Lindley, as you noted, this is all lesser concurrent time.
Right, it means nothing, but we just want to make sure we get it right.
I understand.
For future cases. But one last question, we'll move on to more important things. But do you agree, you've been doing this a long time, to define, if you define a lesser concurrent, an inclusory concurrent offense, the definition of that is it has to be a lesser included offense. Would you agree with that?
I mean, that would make logical sense.
That's what the Court of Appeals has said.
Yeah.
So if it's not a lesser included offense,
how can it be a lesser inclusory?
Which means you look at it in the abstract, then it can't be a inclusory concurrent count. There is this talk about, you look at the facts of the case, those are from pre-Glover cases.
Right.
Like Greer and all these cases that there's, as you know, the law changed. It used to be for lesser included offenses, you looked at the facts of the trial.
Right.
Court of Appeals in Glover and Green come back and say, no, that's wrong. You look at it in the abstract.
Right.
And they've since said, people still cite Greer, and the Court of Appeals said, no, those are pre-Glover, you don't look at those.
Right.
So if what I'm saying is correct, then you are incorrect in your contention.
No, that's true. If the meaning of lesser inclusory within the context of this means, well, it also has to be a lesser included under, Glover and that sort of precedent, then, yeah, my argument has that weakness.
No, I will say, I'm not 100% confident in what I'm saying here.
Well, I'm relying on you here, so.
Yeah, well, that's always dangerous.
No, my argument admittedly did not look at it with that depth. I was relying on CPL 310, and basically the basic instruction of once jury considers this one.
Well, the point is, why use two different terms to describe the same thing?
Exact same conduct, same gun.
No. In terms of lesser included offense, why do we have this concept in Part 300, a lesser concurrent count? Shouldn't they be two distinct things?
Treatments, right.
Different tests.
I agree. Right. I agree. Over my head, unfortunately. If there's any other questions I can answer about the evidentiary arguments or my weight argument, I'd be happy to do so.
Thank you, Counsel. Counsel, proceed.
Your Honor, may it please the court, Morgan Mayer on behalf of the people. In response to the argument brought up by the court regarding the sentencing, the people were also basing our concession on the facts contained in the case, not in the abstract. I do appreciate the court's analysis, it has been noted, but that is the people's position as well based on the facts of the case. I would very briefly like to touch on point 2, the weight of the argument. We do maintain our position that constructive possession of the weapon was established beyond a reasonable doubt, and that the defendant was the only one seen with the gun via the 911 call. The defendant was alone in the apartment for some time. The neighbor had no gun. She had no reason to have a gun. She went inside at 10 p.m. Everyone was inside at 10 p.m. There was no gun under the chair at 10 p.m. It was not found until she went to talk to the police that morning at around 5:15 a.m. or so. There's a gap between the patio that does allow for that space, and based on that, we would just submit that evidence was proven beyond a reasonable doubt of constructive possession, and a circumstantial evidence charge was given, so that is a valid charge.
Anything further, Counsel?
No, Your Honor. If there's nothing further, I will rest on my brief.
Thank you, Counsel.
Thank you.
Case 1036, People versus Portis.
Good morning, Your Honors. Cleo Weiss on behalf of Andre Portis. Unless the court has any questions about the appeal waiver, I'd move just to brief comments on point 2 and point 3.
Proceed.
As to point 2, we acknowledge that the Court of Appeals in People versus Cabrera has held that there's no exception to the preservation requirement.
Do you want us to reach it in the interest of justice?
We do, Your Honor, and I would just note that in People versus David, the Court of Appeals did say that these are meaningful and important questions. They have not been addressed as a question of law in any court yet, but if this court did reach it in the interest of justice, our position is put forth in the brief. And then briefly to just speak on point 3, our sentencing claim. Of course, in People versus Thomas and People versus Baugh, the Court of Appeals has said that the fact that a sentence is a negotiated sentence from a plea is not dispositive of whether this court can exercise its interest of justice jurisdiction to reduce that sentence. On this appeal, we are seeking a 2-year reduction in sentence from 10 to the legal minimum of 8. And I would just ask that this court pay specific attention to Mr. Portis's pro se motions, which are reproduced in the appendix. Give them attention for reasons it's not a conventional reduction in sentence claim, but looking at the procedural complexities of this case, which Mr. Portis detailed in his pro se motions, I would ask that the court pay attention to that in analyzing the sentencing claim. And in conclusion, I would just note that the certificate of conviction must be amended in this case. There's 2 mistakes. Most importantly, it reflects that Mr. Portis is a second violent felony offender when in fact he's a second felony offender, and this affects the type of programming that's available to him while he's incarcerated, and also the date for the 5th count is incorrect.
Very good. Thank you, Counsel.
Thank you. Morning, Nancy Gilligan for the people. It is our position that the interest of justice does not warrant a revisiting of the Bruin analysis that's been proffered by defense counsel. While the court did make reference to the fact that there are potentially meaningful issues here, they also said, look, we just can't go there because there's no record. And it's that lack of record which should prevent this court from going forward and taking any further review. The defendant got his bargain for sentence. It was 2 years more than the minimum which could have been received. It's our position that there is no basis to revisit the sentence. Thank you.
How about the certificate of conviction? Is that inaccurate?
No, Your Honor, we do concede that both the defendant was sentenced as a second felony offender, and the date of one of the criminal possession of a weapon charges is inaccurate, and we have no objection to the certificate being amended. Thank you.
Thank you, Counsel. Case 1037, Carr versus City of Buffalo.
It's always awkward to introduce yourself to someone you've never met on the way to argument. Good morning, may it please the court. My name is Scott Becker. I'm from Kavanaugh Cook, attorneys for the petitioners in this case. This is a original proceeding brought to challenge the City of Buffalo's attempt at taking a real
Let me
property.
interrupt you, just start with a kind of a basic procedural question. Are we still in the status that we were in with Judge Tulio hasn't ruled on the appeal that's before her relative to Judge Carney's decision? Because, and my second question is going to be, is the building still standing?
Yes. With respect to the I am only counsel to the petitioner in this special proceeding. My understanding, so I wouldn't be advised if Judge Tulio had issued an order. My understanding was, as of yesterday, Judge Tulio has not issued the order. And yes, the building is still standing, but I would defer to Mr. Purley, who is counsel for the city in those proceedings, if that's not correct.
Well, surely your client would tell you if Judge Carney is affirmed and he can demolish the building, surely your client would tell you.
I would hope so, Your Honor.
That I'm going to take it down. That would render moot what we're doing here.
Correct, Your Honor. That's exactly right.
The building's there, so, okay.
Proceed.
So, simply put, this case presents the question of whether a municipality's determination to acquire property through condemnation violates the EDPL and the constitutions of New York and the federal government. If there's no foundation in the record for a conclusion that the acquisition will serve a public use. The petition sets forth in detail the ways in which the procedure that the city followed differs from what's in the EDPL, and I'm not going to go through that. That's all outlined in point 1 of the petitioner's brief. But it's important to keep in mind that the reason the EDPL exists with these requirements is to give this court the touchstone by which to determine whether or not there was due process in this case. This is a constitutional right that's being taken away, and absent strict compliance, there's no guarantee that due process has been afforded to our clients. Now, certainly chief among the requirements of the EDPL and the state and federal constitutions is that a proposed condemnation has to be for a public purpose. The EDPL requires that both the notice of the public hearing and the determination in finders identify or describe a proposed public project and specify the public use served by that project. And we submit that the city has failed to do that.
Would you agree that the Court of Appeals has made clear over the years that remediation of blight is a legitimate public use?
Yes, it is, but that's not the question.
I know, I just want to make sure that we understand. Okay, so blight, removing blight, and I think you would not dispute that these properties constitute blight. They're falling down, they're a danger. I mean, it's, your client wants to destroy them. That's how bad they are.
The condition is as it is, yes.
Right, so we have blight. We know that blight equals public use, that the removal of blight satisfies the public use requirement. Your argument is a little different. You're saying in the notice, the public notice under eminent domain procedure law 202A, I believe it is, you have to identify a project, not just a use. Use and project are different. And by project, are you suggesting that the city, in their notice and in their determination and findings, which comes later under 404, by project they have to say, this is, once we take it and we restore it, this is what we're going to use it for? Is that what your argument is in a nutshell?
That is part of it. I think in order for the city to reach that idea of once we restore it, there's got to be proof in the record in front of the city that that is possible to restore it. And I think all the proof at the public hearing and the expert reports and the scientific data and the studies.
Well, isn't there proof in the record by an architect named McDonald that says that this is salvageable?
But that's based on just that's conclusory testimony based on a walkthrough, based on just, oh, we've done this before, we can do this. There's no underlying study, facts, scientific report or study showing that it's possible to save these
look,
structures.
I agree with a lot of the arguments you set forth in your brief, but I don't agree with this one. If it's not feasible to restore the property, because that's really what this is about. It's not, your client wants to demolish the buildings. The city doesn't want them to come down. They want them to be restored. Your client doesn't want to restore them. So this is all about the city's public project and use is restoring and saving these buildings in this historic cobblestone district. But if your argument that, well, we don't know if it's feasible to restore them, they're so bad, they're in such bad condition that you just can't restore them, that is not a reason not to take it. We've had other cases. If they can't take it, if the city can't restore it, then the property reverts back to your client under the article, I think it is 7. We've had plenty of cases where we've said we had the one pipeline case that went to the Court of Appeals. And the argument was, you can't build a pipeline, you'll never get approvals. The Court of Appeals said, no, you can take it, and then if you can't build it, then it reverts back. That's the same thing here, is it not?
Well, but it does, yes, I agree with you that situation does sound like our situation in this case, but I think the difference is that this record is so meager, and the only proof in this record is that these properties cannot be saved. It's literally speculation and wishful thinking that this can happen. And
so I don't get what the big harm then is. If they take it and they can't restore it, your client gets paid, and if they can't restore it, then he gets his property back and he keeps his money. Who's the victim there, besides the city?
Well, our client is. Our client has a plan to develop it and is going to be deprived of that if it's being taken. If it reverts back, then I suppose that's the case.
Yeah.
But I don't think that there's any guarantee that it will.
Anything further, Counsel?
Yes, Your Honor. I just wanted to note the elephant in the room in this case is this demolition order that's outstanding. If that order happens, if that order is affirmed either by county court or if it comes up to this court, all these improvements are going to come down, and then there's going to be no public use at all. So I think that looking at those two elements, the lack of a foundation in the record and the fact that there's a court order saying these things have to come down, the city was without foundation to make the determination that it can take this property and rehabilitate it. Thank you.
Very good. Thank you, Counsel.
Morning, Your Honors. May it please the Court, Michael Purley for the city.
Any further clarification on Judge DiTullio's, the status of the appeal before Judge DiTullio or the status of the building? Can we confirm that it's still there?
The building is still there.
Okay.
There's no question about that. The status of Judge DiTullio's decision is that it remains pending, Your Honor. Judge DiTullio had indicated that she would, at some point earlier this year, likely issue an opinion and a decision in the case, but she did not. I don't mean to speak for her. Just as a point of information, in all likelihood, Your Honor, whatever that decision is, this court will likely review it. That's been the consensus between Mr. Milbrand, who is counsel for Mr. Carr in that case, and me. I would like to address...
Would the appeal come to us? It was a city court, and it was appealed to county court. Would it not then just go to the Court of Appeals?
Your Honor, I do not know. Okay. I apologize. I am not that's sufficiently familiar with procedures and appeals to the county court. In fact, that was my first one. And so we're working through it at the time. So let me start with one point that's in the record. Mr. Carr has maintained that he wants to build the Great Unity Tower. If you look at the plans, and they're not really plans, they're just elevations. The date on them is 2016. He's owned this property for over 10 years. He has done precious little to preserve it. And he came to that public hearing professing to build the Unity Tower 6 years after supposedly it had been undertaken. In that period of time, he'd never perfected, he applied but never perfected an application for a building permit. The frustration level at the city is enormous. I think you can see that in everything he's done. And what he does at the last minute is, rather than take the procedural step that's afforded to him under the city charter to bring an application to destroy the building, which is subject to a review by the Preservation Board, subject to an Article 78 proceeding, a perfectly solid remedy granted to the citizens. What does he do? He, in our opinion, I'm not going to argue the case, attempts to misuse Chapter 516, I think, of the laws of 1978, which governs certain actions in the Buffalo City Court Housing Division.
Well, can I ask you this one question that Mr. Becker raises, is that does the city of Buffalo have a plan, a project for what they're going to do with Mr. Carr's properties if and when they take him through eminent domain?
Your Honor, the first thing the city would do would be one thing that has not done, has really been deferred until now, which is to make sure the building or the appropriate portions thereof are stabilized.
All right, so it would be, the city plans to restore the buildings?
The city does not. The city intends to issue RFQs and or requests for interest, RFIs, to developers who have informally expressed an interest to the city to develop the property.
To restore it, to save it?
To save it,
Okay,
or to save significant portions of it, Your Honor.
And then for what ultimate use?
For commercial use within the historic preservation district that exists down in Cobblestone, which has become an economic engine behind, to the rear of the...
So the city wants to take it, find some developer who's capable and willing to save the buildings, put all this money into it to restore the bricks and the wood and so forth, and then that developer would then find a tenant, some commercial enterprise business who would move in and pay rent and create jobs.
Create jobs,
Right.
yes,
Right, and
economic engine.
that all sounds like a project. What Mr. Becker's point is that in the city's notice of the public hearing I'm talking about, under 202A, it doesn't say any of that.
Your Honor, I don't believe we have to go that far. I think that the use, that the purpose that we defined is the purpose that is constitutionally, both in New York State and federal constitution, is constitutionally recognized.
Where is that written down? Where is it stated that the city says, this is what our plan is? All this stuff that the first time I'm hearing about RFQs and...
It was not stated. I accept the fact, Your Honor, that it was not stated in the notice.
And is it stated anywhere in the record? Sounds like you're saying this is what they plan to do, but we don't have, it's not in the record that that's what they plan to do. I mean, that's just the point. Look, I think it could be easily cured if he's right. Just go back and come up with a plan and state your plan. That's the problem here, but I don't know, but I'll take a look at it.
Well, Your Honor, it would be speculative on the part of the city to ask developers to do anything further at this point. The city needs to control the property.
Well, your argument, counsel, isn't it, that the notice itself gave the public enough information to put them on notice as to what was planned, and that is a restoration essentially of this property, and it's in a commercial area, it's in the Cobblestone district, and that was made, the public was made aware of that.
Yes.
And the rest is inferential.
That's correct, Your Honor.
Yeah. Let me ask you a question about the failure. Your opponent makes a point, I think, that there was an appraisal with a dollar amount.
Right.
But there was no offer to purchase at the appraisal or any other number. Right. And isn't that anticipated within the
That is
statute.
anticipated, Your Honor. That appraisal was communicated to me, by me, to Mr. Milbrand with the statement of your client accepts, if your client is agreeing or is willing to accept that, we will present a formal offer.
So that was an oral, you went to Mr. Carr's lawyer and said, here's an appraisal, we'll buy it for this, an oral written offer. The statute 303 says written offer.
We can, Your Honor, we contend that the delivery of the appraisal was the offer.
Well, let me ask you this. You know, I don't know if I can get there, that the delivery of the appraisal is an offer. Right? It's a delivery of appraisal. Here's what an appraiser says the value is, as opposed to what you're willing to pay for it. Maybe it's some part of that, maybe it's more than that. I'm not sure what the answer is to that. Is the statute provide for a timetable within which the offer has to be made? And does it have to be made, would it have to have been made already?
I don't believe so. I think, Your Honor, the offer can be made prior to the commencement, if this court were to approve the condemnation to go forward, prior to the commencement of the action for the taking.
But the statute says if it's not practical to make it before acquisition, when I'm talking about making the written offer, then it can be done post-acquisition. If it's not practical, do you have any reasons to offer us as to why it wasn't practical to make a written offer before acquisition?
Your Honor, our appraiser was only able to evaluate the exterior of the building.
So that's your practicality argument?
Yes.
So,
This
but
building
your argument is that you already made the offer, but you haven't then because he hasn't been, your appraiser hasn't been on the inside.
Well, Your Honor, to be clear, our appraiser could only view the exterior of the building, other records. If the city has control of the building, it can then make a continuing and further evaluation of the interior of the building in terms of an offer.
So the offer of $250 or whatever it was, that's not a final offer?
It's not a final offer. As a matter of fact, Your Honor, we have we would engage an appraiser because we would have to make a deposit at that point.
So he couldn't accept the $250 because it's not even a final offer?
Well, no, but that conversation, Your Honor, then invited Mr. Carr to provide an appraisal of his own, and he did not. We never heard from him.
Is this within the record that we have?
I don't believe that is in the record.
Anything further, Counsel?
No, nothing further, Your Honor.
Thank you.
Thank you.
Case 1038 in the matter of Anthony J. Proceed, Counsel.
Good morning, Your Honor. May it please the Court, Thomas Babylon on behalf of Appellate, Siobhan M. The first point I'd like to discuss this morning is the denial of due process of the appellant. In this particular case, first I'd like to point out that termination of parental rights requires a high level of due process. In this particular case, in the beginning of the case, the first witness had not even completed her testimony. The court told my client that she didn't surrender her rights, that the court was going to terminate her, and she would have no visitation at that point.
Wasn't it after an attempt to negotiate an agreement for surrender?
That's correct.
And the court was not involved in that negotiation?
Well, the court was involved in negotiation to the point where she told my client.
That was after it was after the agreement was presented or prepared or agreed between all the parties.
Well, it was not agreed upon. There was an offer. There was an offer. It was drafted. My client did not accept the offer.
Didn't she represent that she would, but then decided afterwards that she wasn't?
I think there was some
reflection.
That is the case. That is the case, Your Honor. However, it was improper for the court to tell my client that if she didn't take the agreement, the court was going to terminate her rights and that she wouldn't have visitation.
Your point, I think, is that the court weighed in. When your client made a decision, I don't want to go forward with the offer, I want to continue, and she hadn't yet testified.
She hadn't testified?
She hadn't yet testified. The court didn't hear her side of the story. and yet the court was weighing in saying, I think it's in your best interest to sign that order, or I'll take your kids.
I think the court said more than that. I think the court said, without hearing any testimony, that the court had already decided the case. Not only had it decided that my client had permanently neglected the child, it already had decided as a disposition that she was going to free the child for adoption when she told my client that you're not going to have any visitation.
And she said something like, show us some courtesy here, right? Sign this thing. Wasn't it something along those lines, too?
Well, there was a long discussion, but the point of my brief was where the court specifically had informed my client that in no uncertain terms that she had already decided the case, and that if she didn't sign this agreement, that her rights were going to be terminated, and she wasn't going to have any rights to visitation.
And again, I think in reference to just Scott's Delconte's comments, it was, if you surrender, you'll still have an opportunity to see your child. And I think that's it. And obviously, if that's what you endeavor to do.
Well,
but otherwise, if you don't, then we're going to go on in these proceedings and possibly it could be terminated.
No, she didn't say possibly. She said the court will terminate your rights. And she also said that you will have no visitation. So she not only
wouldn't have visitation but for the fact that she's surrendering. If she surrendered, she could have the visitation.
That's correct, Your Honor. And the child was placed.
I'm sure
with
she
a
understood that at the time because it negotiated. She had an attorney, right?
She did.
And it was negotiated between the attorneys. She was made part of those negotiations, right?
Yes,
He understood them all. I mean, and the court wasn't in that room while they were being negotiated, correct?
Well, the court was they put the proposed agreement on
Right,
the
but
record.
the court was not. It wasn't in chambers with the court, specifying, indicating what these terms of the surrender.
Well, the terms of the surrender were basically presented prior to the agreement being drafted. So they were presented prior in court to the agreement being drafted.
And
so
the court was aware of that, right? During the negotiation process, the court was aware of that.
The court was aware of that, and there's no, I don't contest that if she had signed the agreement, she would have been entitled to visitation. That's correct. I'm not disagreeing with that. My point is, it was
If she was successful at the hearing, what would have happened?
If she was successed at the hearing, multiple things could happen. There could have been a determination that she did not permanently neglect the child. There could have been disposition where she would have had a suspended judgment.
A much more favorable outcome than visitation with the child.
Well, she could. It's possible. Yes, it is possible.
It's a fine line, and judges in criminal court and all courts face this, is advising litigants of possible outcomes neutrally, or doing it in a way that coerces and pushes the party to take certain action. And your argument is, in this case, this was coercive. And, I mean, the one line that really stuck out at me was, show some consideration for these people who've been working hard. What they were doing, I could be wrong, but they were working hard to draw up papers to take her children from her.
That's correct.
Like, show some consideration for these people who are trying to ruin your life by taking your children. That seemed to be not a proper statement we would look for out of a judge presiding over something like that.
And I agree with that, Judge. And not only was it coercive, but it told my client and it was clear on the record that she had already decided the matter. She didn't need to hear any other witnesses. There was no need for a dispositional hearing. She was going to take this child away.
But all that took place. There was a dispositional hearing. She had an opportunity to testify. She had an opportunity to examine witnesses, cross-examine witnesses. She had all that opportunity. She took advantage of it all, right?
That's correct, Your Honor. But the right to a fair and impartial judge is a fundamental right of due process, and my client was denied that.
Was there anything else that she did that would be deemed that? I mean, it appears as though the evidence was admitted without objection of her attorney. There was other instances where she didn't exhibit any bias during the hearing.
Well, there was some objections with regards.
Well, there are objections, but the objections to some of the evidence. The attorney did not object to certain things, so there was unpreserved.
He didn't object to some evidence, that's correct. He did object to the CPS records coming in, that they were hearsay, and that's another one of the points I'd like to discuss this morning, and that there was no foundation laid for those records that come in as business records. There was no testimony from the witness with regards to the foundation, and although there was a certification, the CPLR does not provide for a party to certify its own business records, which is what occurred here. The court was required to take that foundational evidence from a witness, which they did not do. And so when they took that into evidence the CPS records over the counsel's objection to hearsay that was improper. The records were clearly hearsay because there was no foundation set that would state that they were business records, which would be an exception to the hearsay rule.
I want to ask you, counsel, about another interaction that the court had with your client, where she says to the effect, if you don't agree to this surrender, she says, this is going to keep your child in the system for another few years if you go up and appeal and back down.
Yes.
Right?
Yes.
Just end this.
She did
Because
say
if
that,
I
yeah.
decide this, you're going to appeal. It was, your point, though, is these comments taken together were discouraging this mother from, it was an attempt to get your client to sign that agreement.
Well, yeah, yes, they were
It was coercive, is your point.
It was very coercive, Your Honor. But my bigger point is that the court laid out in the record that she had already decided this case before she had heard any evidence. So she wasn't going to come back and change her mind after she had heard the evidence. If
She reserved decision too, right? She didn't come up with a bench decision or make an oral decision on terminating your rights now.
She did do a, well, it wasn't an oral decision, but
She reserved a decision, a written decision.
I believe there was an oral decision that was incorporated into the written decision. But yeah, she did do a decision. But the decision was not contradictory to what she'd stated on the record, that she was going to do this, and she did do it. And because of that, our position is that my client was denied this fundamental due process, Your Honor.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the Court, Joseph Marzocchi on behalf of the petitioner respondent, the Onondaga County Department of Children and Family Services. If the Court will allow me, I'd just like to briefly emphasize that during all of these conversations, counsel for the respondent appellant was present. Counsel never objected. In fact, during one of the exchanges, it was the exchange when the judge was discussing some of the holiday schedule. Counsel for the respondent appellant actually turned to his client and asked her to strongly consider what the judge was telling her. For that reason, it's my client's position that the court's attitude, whatever it was, did not affect the proceeding at all. And as the court pointed out as well.
Well, the communication from the judge concerning what could happen before the hearing was undertaken, that communication is what actually did happen after the hearing was done, correct?
You mean to say the court?
The result of the hearing was exactly what the court said it was going to be and why the mother should sign the papers. What the court said is what happened at the end of the hearing before any evidence was put in or any opportunity was given to the mother to put in evidence. Is that fair?
I think the court was contemplating a possibility and the effect that a termination would have on her contact with the child. I think there appeared to be some misunderstanding on the parents, the mother's part about what exactly was going on. There had been multiple conversations in court about a termination, what a settlement would look like, what a surrender would look like, what she would be entitled to. The court had asked her to speak to her attorney. She had agreed to that, and it still seemed like there was a disconnect between what was actually happening in the proceeding and the respondent appellant's perception of what was going on.
Just a second, counsel. I'm sorry, but mother says it's the consent of the fact I'm giving up my child. I'm not going to do that. And then the court says, then I'm going to do it. Mom says, I'm not going to sign it. Court says, I'll do it. And then let's go ahead with this hearing. Right?
Right. And I understand the court's point that, like Justice Whalen had said, this was identical to the eventual order. I think the only response to that is the court did hold the hearing. The respondent did have an opportunity to testify. The respondent repeated what she had actually said during the second appearance, that she had essentially admitting to the allegation contained in the petition that she hadn't enrolled in or cooperated with a substance abuse treatment program.
Well, you'd agree that the mother had a right to a judge who did not prejudge this proceeding before the opening of proof?
No question about it, of course.
Okay.
And unless the court has any other questions, I will rest on my brief.
Thank you.
Thank you.
Case 1039, Sevilla versus Torres. I believe we have a video appearance by counsel. So we just hold on a minute. Counsel, you're on mute? Yes, very good. Can you hear us?
Yes, Your Honor, thank you.
Your opponent has submitted, so please proceed.
Good morning, Your Honors. May it please the court. My name is Catherine Festine. I'm appearing for appellant Jean Sevilla. Your Honors, this case is about a box that wasn't checked and how that led to a dismissal with prejudice of my client's family offense petition. It's our position that family court impermissibly applied a heightened pleading standard to a petition that was prepared by a pro se litigant, and when counsel was assigned, they did not provide meaningful assistance. And first, I'd like to discuss the petition itself. This was a form petition. It was designed presumably by the court or the Office of Court Administration, and it was meant for use by pro se litigants wishing to bring a family offense proceeding. I think as many judges know, family court petitions are usually composed pro se, and then if somebody is an indigent defendant, they're assigned counsel after the petition is already submitted. And in this case, the family offense petition that was provided by the court provided boxes to check for alleged family offenses that correspond to penal law offenses. The elements of each of these offenses are not provided on the form. Now, I don't believe that the courts of New York State wish to set up pro se litigants for failure to overcome the pleading stage of litigation. Yet in this case, family court's approach to the petition has set up pro se litigants for failure, for the simple reason that such a litigant will not know the elements of every family offense and is likely to check the wrong box, but particularly in the case of family offenses like harassment. There are 4 different kinds of harassment listed on the petition and no hint as to what differentiates each of them. The case law is clear that a family court has to look at the substance of the allegations to determine whether a litigant has a claim for a family offense. It is not a matter of whether the right box is checked. Here, the petitioner made specific allegations that at least show a claim for harassment in the second degree, and the factual allegations put the respondent on notice of the alleged issue. It's also our position the petitioner was failed by counsel. Counsel for petitioner was faced with a motion to dismiss, and instead of making a case that the facts as alleged made out harassment in the second degree, counsel didn't address the issue at all. And counsel also could have amended the petition and did not. The result in this case I felt was particularly egregious because the petition was dismissed with prejudice. After the judge had told my client many times, throughout the proceedings that he would get to make his case at trial. So I don't think that is proper. Does the court have any questions?
No questions, counsel. I think we have your argument.
All right. Thank you very much.
Thank you. Case 1040 and 1041, Grammatico versus Lamar DMD. Mr. Strauss is appearing by video.
Judge, he's not starting his video.
He's checked in?
He is in the court. Here he comes. His video is not working, but his audio seems to be.
We'll proceed with audio.
Please, court. Gerard Strauss for plaintiff appellant Robin Grammatico.
It's plaintiff's position that we'd like to address three issues here. The first is the inadequacy of the defendant's expert affidavit. The second is the fact that this is a classic battle of the experts in which the court below improperly determined issues of credibility, in which on the one side, defendant's expert opined that the lingual nerve was not injured in the course of the March 3 extraction, where three equally qualified experts opined otherwise. And four, that the lack of informed consent claim was improperly granted and the case dismissed, and the claim dismissed when this was in fact a claim essentially that the plaintiff had not specified a lack of informed consent in the bill of particulars, and as a consequence, the case law says that the proper route for the defendants to have taken was pursue their remedies for failure to provide discovery under CPLR 3126.
Mr. Strauss, could I ask you a question?
Yes.
Am I hearing you correctly and reading your brief correctly that with respect to the March 3rd, 2016 extraction and bone graft, you do not believe that the Lamar brothers, the two experts, that their affidavits met the defendant's burden of proof going forward?
That's correct, Your Honor, and I'll explain why. First of all, the affidavit of Frank Lamar does not address whether there was or was not negligence or causation with respect to that procedure. The only affidavit that was submitted with respect to the procedure in which negligence and causation and damages are addressed is the affidavit of Jim Lamar. In his affidavit, Jim Lamar builds a case based on, among other things, his assertion that the lingual nerve was not damaged during the procedure. However, on the record, it's clear, and he admits, that he could not see or feel the lingual nerve at any time, that at no time was he able to determine whether he was in contact with the lingual nerve during the course of curettage, which is the scraping of the infection off of the top of the nerve. And at no time afterwards were any tests done or any imaging taken that would have revealed whether there was injury to the nerve.
Well,
so in fact,
don't they have proof in the moving papers of the defendant with respect to their initial burden that the plaintiff, although she initially felt numbness in her chin in that area, that went away. She had no complaints thereafter for a significant period of time. Don't they say that? And if that's the case, doesn't that tend to support Dr. Lamar's claim that there was no impingement of the nerve? Numbness coming from the nerve.
Well, our assertion, Your Honor, is that the way that Dr. Lamar reasons his way to the conclusion that this was more likely some sort of spontaneous nerve irritation depends upon, as a critical cornerstone, his statement that the nerve itself was not injured. Because if the nerve had been injured, then there's really, this is the way that he states it, that because the nerve was not injured, that it's only because the nerve was not injured and the fact that there was no complaint of symptomatic numbness subsequent to the procedure that that he can conclude that the nerve was. It's a circular reasoning, Your Honor.
Mr. Strauss, but your point is that doesn't make any difference because your expert says the aggressive cleaning of the socket was deviated from the standard of care and caused the numbness and
That's correct, Your Honor. That's correct. That's what our expert says.
Mr. Strauss, it's Presiding Justice Whalen. I just want to, I know you can't see us, I presume, right? Because we're hearing you just.
I can see you on my screen. My video is working.
Oh, very good. Okay, then I don't feel we need to identify ourselves. So let me ask you this. The only way it does make a difference, because you were just responding to Justice Del Conte's question. The initial question is, did the defendant carry their burden, which then would shift the burden to you, which is when we can take a look at your expert information, right? Your initial argument is they never even carried the burden. We don't have to get to your papers. And I think that's where Justice Lindley was going with the initial question. You want this to get to be, you want this to be a battle of the experts, but the question becomes in the first instance, did the defendant carry their burden? And you're saying they did not.
That's correct, Your Honor.
And one reason they may not have carried the burden, to expand on your other argument, is the doctor, I believe it was Jim who performed the procedure on the 3rd, not Frank. Yes. He acknowledged in his own papers that he used this curette in the manner that he did, that there was contact with a nerve. That was in their own moving papers, was it not? So if that's the case, then there's issues of fact arising from the moving papers, which means you didn't meet your initial burden.
Correct. That's correct, Your Honor.
Very good. Anything further, counsel?
No, Your Honor.
Thank you.
Good morning, Your Honors. May it please the court. Kara Adelman here for the respondents. Based on what Mr. Strauss says, I'm going to try to focus on that because I really hit up against the word count limit on my brief, and I don't want to continue to be too wordy. We maintain that defendants did meet their initial burden. The causation opinion that was rendered by Dr. Lamar was that given Mrs. Grammatico's past history, the decades of dental records, we have years of records after the subject procedure as well, shows that the type of injury that she now claims would not have occurred in the type of procedure that took place on March 3rd in the absence of severance of the nerve. That was one of the opinions that he rendered, and why, given her dental picture, he believed that there was an alternative cause to her current complaints. The issue is that at no time has any subsequent treater ever said her nerve was severed. At no time did plaintiff's expert opine that the nerve was severed, even in opposition to Dr. Lamar's affidavit. And at no time was it claimed the nerve was severed until the instant appeal.
I'm sorry, you explained it, but what was the alternative theory of the pain then if it wasn't a severed nerve?
The alternative theory was, given her anatomy, given the years of absence of these types of complaints, is that she had a spontaneous nerve irritation, which sometimes occurs in patients. And the type of temporary paresthesia, which we do concede that she had some in the weeks after the incident, is more of the type of thing that you would expect to see after that kind of procedure, that can happen. And that because it resolved and she continued treating with us for years with no other such complaints.
Shouldn't that be for the trial of fact to get two alternative theories? And let me ask you this, though.
Yes, Your Honor.
There is evidence that the curette that Jim used may have scraped the nerve. when he
Yes,
was
Your
cleaning
Honor.
out the debris there, the infected material, as it's called.
Yes, Your Honor.
You agree that there's a reasonable view of the evidence that that might have happened?
Oh, yes, Your
Yes,
Honor.
that-
I'm not denying that
You're not
that's in
denying
there.
that, and you're not denying that Jim couldn't even see, he was a blind procedure. He couldn't see what he was scraping. He couldn't see into the mouth. He was relying on x-rays.
He could, saying he couldn't see it, he couldn't directly visualize the
Visualize it.
nerve.
He did say later, he testified that he aggressively debrided or he aggressively cleaned it with a curette.
Yes, Your Honor, and he defined aggressively, that, I believe later in his testimony, and it's in the record, he defined what aggressively meant, which was as aggressively as he needed to remove the
All right.
infectious
So you would agree with me
tissue.
that there's at least an issue of fact of whether that curette came into contact with a nerve? No?
Oh, I'm sorry, go ahead, Your Honor.
The plaintiff's expert opines that that is a deviation from accepted dental practice to take the curette in this situation. You're not even supposed to use a curette, he says, but to scrape the nerve. That's what he says.
He said that it was a deviation to deliberately scrape the nerve, sir.
Okay. So if he did it by accident, then it's not a problem?
Plaintiff concedes in his brief that an incidental contact between the surgical tool and the nerve would not constitute malpractice or a deviation.
Very good. Anything further, counsel?
Not unless you have any questions.
No questions. Thank you, counsel.
Thank you.
Thank you, Your Honor.
Case 1042, Village of Newark versus CSEA, Inc. Both counsel are appearing by video. Counsel, very good. Can you hear us?
Yes, Your Honor.
Counsel Conroe?
Yes, Your Honor. Can you hear me?
And we can hear both of you. Very good. Proceed with your argument, counsel. Thank you.
Good morning. May it please the court. Aaron Kaplan, appearing for Darren J. Rylowitz, Civil Service Employees Association, representing respondent appellant. The SEA brought this appeal for three reasons. First, the Supreme Court improperly awarded attorney fees and costs pursuant to Rule 130-1.1 for a pre-litigation demand for arbitration. Second, the Supreme Court abused its discretion in awarding attorney fees and costs pursuant to that rule for demand for arbitration that had merit, that ultimately would not have been stayed, and certainly was not frivolous. And third, the court improperly awarded fees on fees, those being fees that the village's council incurred as a result of seeking an award of attorney fees and costs. And if I could just speak on the first point, in New York, courts follow the American rule that fees and costs are borne by the party that incurs them.
Well, that's the general rule, but I think your opponent is arguing that that general rule doesn't apply because in this case we're talking about frivolous conduct, and isn't that really where we've got to look here to determine whether or not there was frivolous conduct at the point that I guess it was a labor relations specialist, and I apologize if I mispronounce her name, but Chichester, when she filed the requirement for the demand for arbitration, I think that's when the dialogue began between her and the village concerning whether or not she should even be filing that, right? And there was a notice that if you do this, we're going to consider it frivolous, and we're going to seek fees and sanctions.
Yes, Your Honor, Ms. Conroe did provide that claim to Ms. Chichester, all of this happening pre-litigation. Rule 130-1.1 applies to proceedings before the court. The court is limited, as Court of Appeals held in AG Ship Maintenance Vilezak, to providing awards of attorney fees and costs where the rule created by the courts would so state, as it applies to proceedings before the court.
Right, so your argument is that even if it were frivolous to file this demand for arbitration, even if it was wholly without merit, there's no basis for sanctions because this was pre-litigation, it wasn't a civil action. But let's assume, for the sake of argument, that sanctions were available for this, even though it occurred before the action was commenced. There's a distinction, is there not, between a contention or a claim that lacks merit, a wide distinction between a contention that lacks merit and a frivolous contention.
Yes, absolutely.
There are a lot of contentions, we have a lot of them here today, that we're going to say lack merit. It would never occur to us to say they're frivolous. So the fact that this demand was withdrawn, and maybe upon reflection, maybe the village was right, maybe there's some state laws that say you can't pay for these types of benefits, but to get to frivolous, it has to be a pretty high burden. Maybe your client was wrong, maybe you don't even concede that, but to impose sanctions, it's got to be wildly, and I mean, it's a rare thing to impose sanctions for frivolous conduct. So
yes.
we could say that the court abuses discretion, even if he had authority to do it. Correct?
Yes, Your Honor. In this case, the argument whether or not the petition would have been granted and the demand for arbitration stayed is certainly questionable. As we have presented to this court, there is certainly an argument. There's no case law on the issue that the demand for arbitration would have brought before an arbitrator, and that the court considered specifically whether a court can provide either reimbursement or cover the costs of statutory contributions to the retirement system. That's never actually been addressed by the courts. The reflection of the case by the CSEA legal department ultimately resulted in a sort of an administrative decision to withdraw the demand for arbitration based on some of the negotiation history. However, that is not to concede that it was frivolous or without merit in the first place. I believe the plain language of the collective bargaining agreement supports the grievance. And as the village points out in their brief, CSEA has a duty of fair representation to its members. And so it is not so simple to simply withdraw a grievance that is supported by the plain language of the contract. But that certainly would not make, it doesn't rise to the level of being frivolous under the rule.
Did the village provide this authority? I know they referred to the statute, but there's some documentary authority that supported their position. Did they provide that before the demand for arbitration was filed, or was that out much later?
Not before. It was a couple days after the demand for arbitration was
filed. So it might be different if the union representative was provided with this, hey, look, this has no merit, even though the CBA, he's clearly entitled to it under the CBA, Article 16. So, I mean, it's hard to say it's frivolous there, because it's right there in black and white. But this information that says you can't get it was not turned over pre-filing of the demand.
That is correct. And it was not entirely clear-cut as it was, because it was a draft of the collective bargaining agreement. Not only was the tentative agreement that gave rise to the collective bargaining agreement plain in its language supportive of the grievance, but it had to be looked into it was required a dive into a draft that was sent between the chief negotiator, including the chief negotiator of CSEA that no longer works for CSEA, and the demand not to file the demand for arbitration, if I can call it such, was made to a non-attorney representative. It was then passed along to the.
Well, not only that, counsel, it was made to the LRS, is what you're referring to, right? It was made to an LRS that was relatively new to the job and was trying to get her arms around all of the pending requests for arbitration. And as Justice Lindley pointed out, it was like 2 days after the demand for arbitration that the materials were provided. And my notes tell me it was about 164 pages of materials that that LRS then forwarded on to counsel's office and did so promptly. And so the timetable of when all this transpires is pretty tight, it seems. And should we take into consideration that the LRS was new to the job and was just getting her feet under in this respect?
Well, Your Honor, I do want to clarify that the LRS was not new to the position of labor relations specialist. She was, however, somewhat new to the to dealing with the village and dealing with their contract.
Yeah, I guess that's what I was referring to, the possible arbitrations and grievances that were filed with the village.
Yes, absolutely. Ms. Chichester was not familiar with the parties. In fact, she asked for a meeting to introduce herself. That's where the matters were discussed. And the entire timeframes are very short under this grievance and arbitration procedure. Now, there may be some discussion about what steps were followed or the like, but ultimately, there is a time frame for filing a demand for arbitration. Ms. Chichester was following that, making sure to meet those timeframes. If she had waited further, she risked missing the timeframes, which is something that no representative would ever want to do.
Okay, I think we have your argument, counsel. Is there anything further?
Not unless there are questions, I'll rest on my brief. Thank you.
Very good. Counsel, proceed.
Good morning, may it please the court. I'm Mary Lou Conroe with Coughlin and Gearhart, and I represent the respondents, Village of Newark. In relation to some of the issues that were raised by Mr. Kaplan in the court, I would like to just note that in relation to the issues regarding when the demand for arbitration was filed and when I submitted my documentation to Ms. Chichester, during the January 10th meeting, we discussed the grievance. I was clear about what the village's position was during that meeting. At no time during that meeting did Ms. Chichester say she was going to file the demand for arbitration. She indicated if we didn't resolve the matter, she was going to be filing the demand. I told her that I could provide her with the information that I was talking about, and she said that she would look at it. I sent it as soon as I could put it together and get it out. But she called her office that day after she walked out of the meeting, and it's clear in her affidavit that this is what she did. As she walked out of that meeting, she called her office and told them to serve the demand for arbitration. So I didn't have the ability to give her the information. After she received that information,
Counsel, there was a relatively tight time frame for her to file the demand for arbitration or otherwise risk waiving the right to arbitration. And isn't that responsible conduct to just preserve your client's rights by filing?
No, the timeframes have been waived. We had.
I'm sorry, say that again, counsel.
I'm sorry, my light just went out. Hold on a second.
That's right. There you go.
I guess I'm not moving. In relation to the timeframes had been waived because we were in the process of getting a new chief. There was a number of grievances that had been filed. They were in the process of switching over the LRS. We moved from one.
There seems to be a counsel. There seems to be a conflict in the record. I believe your opponent's position is the village did not offer an extension of time to file for a demand for arbitration. So there seems to be a difference of opinion there.
We had waived all timeframes under the grievance procedure. That you did not. The timeframes were waived for filing the grievance. The timeframes were waived for moving the grievance forward. And as can be seen by my affidavit, I stated that, and I showed the emails where the union had asked to move a grievance to step 3, that if the timeframes had not been waived, should have been moved by December 4th and was not moved until December 30th. And we did not argue that that could not be moved to step 3. That shows that the timeframes were waived, or we would have taken action to prevent that from moving forward. All timeframes were waived because we didn't have a chief, the LRSs were changing, and it was just too difficult to try to process everything timely. So everything was waived. And I believe if you look at the affidavits of my mayor and my chief, both of them will state that they told the union that the timeframes were waived. So I think that that's important, because if when she could have said at the meeting, all right, let me have your information. I believe I need to file this demand for arbitration. Will you give me an extension to file the demand? We would have obviously said yes, because we'd already waived all of the time frame. So we were stunned when we received that demand for arbitration. And that's why we feel that this is frivolous. And I would like to point out to the court that if you look, I think this is where Judge Nesbitt had an issue. If you look at the affidavit that was filed in opposition to the stay, you will see in paragraph 10 that the union states that there is no merit to the grievance, so you do not have to worry about us filing this again. And then when in their papers supporting the opposing the attorney's fees, they argue that the grievance does have merit. So they're arguing both of these. And I think that Nesbitt just found that everything that the union did up to then was just how can they say in paragraph 10 that, Judge, you don't need to worry about this stay because we will not be filing this grievance for a third time because we made a determination that there is no merit to the grievance. Then they turn around and argue that there is merit to the grievance.
We've heard that argument. Okay, very good, counsel. Anything further?
Unless you have any other questions for me.
Very good. Thank you, counsel.
Thank you.
Case 10-4-3, Rosbaugh versus Town of Lodi. Counsel, proceed.
Good morning. May it please the court, Alan Pierce of Hancock Esterbrook for the appellant Town of Lodi. Sorry, my voice has seemed to have lost me a little bit. This appeal presents two legal questions that I believe are very straightforward and require a reversal on both. First issue is the award of treble damages against the town. And there is basically an impenetrable public policy, federal and state, against the award of exemplary damages like treble damages.
Just, counsel, if I may, the statute doesn't say treble damages. It's trebling the stumpage value. Because even within the statute, there's other damages, restoration, for instance. You don't treble that under the statute. So if the wrongful cutter leaves debris and garbage around, and you have to remove that, you don't get trebling on that piece, correct?
I think that's correct, Your Honor. But here, the stumpage value was trebled. And that is,
and because stumpage value is a very specific measure based on the merchantable value of the wood alone. Correct?
I think that's correct, Your Honor.
Right.
But I submit that if you have multiple forms of damage, even if only one of them is trebled.
But that's because perhaps the value of the tree is hard to ascertain. It's not necessarily the value of the wood that's contained within the tree. Is it always, counsel?
Well, there was expert proof here presented by the petitioners that was accepted by the court.
Which would have been board foot and the value of the wood on the, perhaps on the market, the wood alone. But it didn't capture the value of the tree. Say what it provided for wildlife habitat or shade or any of the other aesthetic values of the tree.
Well, I don't know that if that's covered by the statute. But here, the court trebled it against the municipality, and I mean, the case law is very clear, and petitioner relies solely on.
But just please, I'm sorry, but they trebled it against the tree service. The municipality didn't do the cutting. They hired someone else to go out there and do the cutting.
Well, the damages were trebled against the town.
Right.
The tree service is
So
gone
the tree
from
service
case.
should pay more than the town here.
Well, they're gone from the case.
Well, that's, the record says they settled, they paid their share.
Yeah,
We
yeah.
don't know what that is.
Well, we have the judgment against us for a trebling of that.
Right, so your clients, whatever was trebled, we know that the stump value was trebled.
Yes.
And your client says that that's punitive, and because your client is a governmental entity, that it's improper, and you make a lot of sense there. However, we do have the Swenson case. From
Yes.
2015 that Judge Porsche relied on. There's a lot of talk about that in the briefs. We say there, the issue there was different. There was no municipality there. It was two private parties, and arbitrators can't award punitive damages. So the question there was, did the arbitrator have authority to impose treble damages? And we said yes, because they're not punitive damages. They're obviously not punitive damages. Those are, punitives, there's no limit to them.
Right.
It's based on wanton and gross negligence and so forth. But we went on, perhaps in dicta, we said, not only is it not punitive damages, but it's not punitive in nature.
Yeah.
That's the troubling part in this case.
Yeah,
How do we get around, how do you get around this decision where we said in dicta, it's not punitive in nature, treble damages?
Well, because treble damages are really just a different form of exemplary. Punitive is exemplary. They're not, as this court said in Swenson, punitive and treble are not the same. They're different forms of the same thing, exemplary damages. The way to get around it is just the way the third department did. The third department in a case under this exact statute against a municipality said, no, you can't treble them against the municipality, Scott versus Town of Duanesburg. But then, in 1991, in 2016, in Bacchus versus Lime Adirondack, when it's a private entity, yes, treble is fine. So the third department's distinction is right on point. It's consistent with Swenson. This court now has to say, we agree with the third. I submit you should agree with the third and say, yes, the difference here is whether it's a municipal defendant or not under this exact same statute.
Right, couldn't we have said, hindsight's 20/20, but we could have, the difference in Swenson was that the arbitrator was not imposing any damages that were punitive in nature. The arbitrator was just enforcing the statute. It was the legislature in passing Section 861 that imposed treble damages. Here, the question there was who has authority to grant it. Here, the question is who can it be granted against? That's why this case is a little bit different.
Yes, I submit it's different, Your Honor, because we are a municipality, just like, and I've cited a plethora of cases, federal and state, that treble damages are not allowed against a municipality by public policy. This court in the McCabe case, it's difficult because you start talking punitive. In the McCabe case that's on page 12 of my appellant's brief, this court recognized under the rule that an insurance company can't be required to pay punitive damages awarded against the insured. And this court distinguished the fact that, yeah, you can't do that, so you can't do that. It's not allowed. So it's caught up in that punitive versus treble, but I think that's easily resolved. They're two different things under the larger umbrella.
Is it your understanding that the legislature in passing this law for treble damages, if you cut some of those trees down without good faith, it meant to punish that conduct to deter it in the future, thereby creating a windfall for the tree owner? Is that your understanding of what it was, that it was intended to deter reckless tree cutting? And to deter it, we're going to say you got to pay 3 times more than what the value is of the stump value.
If you met the particular requirements under the statute for trebling.
Which would, in your mind, then suggest that this is punitive. We're trying to deter people. That's what punitives are.
It seems that way, and cases often talk about trebling being punitive in nature, including this court in McCabe did, that trebling under judiciary law 487 is punitive in nature. This court said that in McCabe, that's on page 12 of Appellant's brief. And I'd briefly like to talk about the interest, because I get the idea that this started as a lawsuit. What's interesting is petitioners rely on this court's decision in Swenson on the treble damages issue and ignore it on the interest issue.
Well, Judge Porsche here just sua sponte changed interest. It was, nobody asked for it. Nobody had any complaints. The arbitrator awarded interest from the date of the award. Judge Porce then confirmed the award.
Right.
And then later on, in some subsequent language, said, okay, we're going to run interest from the date that it was commenced. Nobody asked him to do it.
Not that I saw. I was shocked when I saw the judgment that had interest going back there, because the Court of Appeals says if it's an arbitrator's decision, it's from the arbitrator's decision. CPLR 5002 says it's from the report or decision.
Might have just made a mistake. He just didn't realize.
Right. So.
Anything further, counsel?
Not at all, Your Honor.
Thank you.
Very much.
Case 1044, Lippes versus Toddy. Mr. Lippes is appearing by video. Counsel, can you hear us? You have to turn your, yep, there you go.
Yeah, Your Honor, I'm Richard Lippes, representing the plaintiff. And in this case, there are only 3 issues involved. Whether there is personal jurisdiction against the Zarwenbaum law firm, whether personal jurisdiction exists concerning Joseph Toddy, and whether the plaintiff can sue for punitive damages. As to the first issue, the landmark decision of Fishberg versus Doucette, we believe is dispositive of the issue. The defendants in this case purposely projected themselves into New York by requesting the plaintiff to be a co-counsel in the case, in the underlying case. And because of that, they established a direct relationship with both the plaintiff and with the clients. The participation in the case continued with calls, faxes, and emails, examples of which are in the record.
So, counsel, you're arguing that they initiated the contact, and then there was a quantity of other contacts that came into New York through email and otherwise, and therefore they satisfied the jurisdictional question. Can you address the punitive damage claim question?
Yes. The basis of the defendant's motion to dismiss the punitive damage claim was solely based upon the fact that there is no punitive damages allowed, with some narrow exceptions, in a contract action. We don't dispute that, but the defendants ignored the fact that the gravamen of the punitive damage complaint arises from the claim of unjust enrichment, the tort of unjust enrichment. And they didn't even address.
Does it matter, counsel, does it matter that that damage claim flows directly from the contract dispute and not from a separate tort?
In the facts of this case, I do not believe that's the case, because we allege that the conduct of Mr. Toddy violated both the ethical rules and was egregious. That had nothing to do with the fact that there was a contract established between the plaintiff and the defendants. Mr. Toddy, on his own, decided how much each plaintiff would receive from a common fund. He never approached the court to approve it. He never went to any independent authority to make a determination, which is a violation of ethical rules. Then, to add injury to what he did, certain of the plaintiffs would not agree to the amount that he had allocated to them. So he then, again, unilaterally and on his own, negotiated between the recalcitrant plaintiffs by increasing the amount that they would receive at the expense of his other clients, who he reduced their allocation. And then he asked me to contact the clients to convince them to accept the settlement. This is totally unethical, and that's not all, Your Honor. He refused to pay the experts that they asked me to obtain, so that I was required to pay those experts. In fact, the amount that I had to pay the experts was less than the amount that Mr. Toddy had allocated for me for attorney's fees. So I wound up not only not getting paid, but losing money. And this was all done unilaterally by Mr. Toddy for his firm to be able to fully pay his expenses, and also to increase his attorney's fees from what the initial agreement was.
Counsel, anything further?
Not unless the court has any questions.
Very good. Thank you, counsel. Case 1045, Peters and Associates CPA versus David Upcraft. Proceed, counsel.
Good morning, Your Honor. Merritt Locke, Saunders Kaler, on behalf of the appellant David Upcraft. Today I'm here appealing a decision of the lower court which denied Mr. Upcraft's summary judgment motion on his dismissing the second cause of action, dismissing a claim for common law duty not to impair the goodwill. Your Honors, I think that my brief outlines the two different issues here. One was the fact that the court did not look at the entirety of the agreements between the parties. They only looked at the non-compete agreement. There was a purchase agreement with provisions that survived the closing of the agreement, along with the non-compete agreement. And in the entirety of that agreement, it modified the common law duty that was set forth in Mohawk Maintenance. We're not disputing that Mohawk Maintenance sets forth the common law duty not to impair by soliciting anybody that you had prior to selling your business. But we believe that the language in that, which was then further modified by the Court of Appeals and MGM, modified that language, which then made it so that the common law duty was extinguished by the writings. And if anybody has any questions on that one point, if not, I'll move to my next point.
Please do.
Okay, my next point is that even if Mohawk Maintenance is in play here, and in fact that the agreements between the party did not modify that, my client just simply did not violate that duty. The facts are such that he was terminated from the employment on October 1st of 2018. It's been a long time, so I think it was 2018. He had no further contact with the Bank of Utica. The Bank of Utica terminated its relationship with Peters and Associates, and only after that did they offer a job to Mr. Upcraft. And
One month later, right?
That was later. It was after the fact.
Right.
About a month later, yes.
November 2018, your client was terminated.
Yep.
And then the very next month, he goes to work for the Bank of Utica.
He was terminated October 1st. He didn't go to work for the Bank of Utica until December of,
Right. Okay,
end
so
of
a
December.
month and a half. So, but do I have it right that Mr. Upcraft, while he was with Peters and Associates, he serviced the bank.
Undisputed, Your Honor.
He provided certain financial services, tax, whatever. When he got to the bank, when he was hired a month or so later, the former client of Peters, he did the exact same work, thereby obviating, the bank didn't need Peters anymore because they had Upcraft. He was doing the exact same things.
Nope, that's
Nope,
not
true?
correct, Your Honor.
Okay.
What happened was, the Bank of Utica hired a whole new outside accounting firm to do many of the jobs that Mr. Peters had done, Mr. Upcraft had done while he was at Peters. It was only certain jobs that he had been approached by the Bank of Utica, including to help out with a senior level officer at the bank that was going to go part-time. So he was only going to work part-time, and he was going to help with some, but the majority of which were farmed out to another accounting.
But you would agree, hypothetically, if Mr. Upcraft did the exact same work that he did for the bank at Peters, and he just switches over to the bank, then there's a problem with the implied duty.
Respectfully, I would not agree with that, Your Honor. I would say that there was a first cause of action in this, because there was a non-compete. My summary judgment motion was granted because that was limited to only working for outside firms and not being employed. This is only the duty that is implied by Mohawk Maintenance, and that is to not solicit. Not to not compete, but to not solicit. And we believe that because the Bank of Utica approached Mr. Upcraft had one conversation with the Bank of Utica before Bank of Utica approached him, and that was, and there's a reason for this, he had one conversation, and that was, I have been terminated, and someone from Peters and Associates, this is October 1st, will contact you. Mr. Upcraft had a financial interest in this client staying with Mr. Upcraft because there was additional monies that would be paid to him. So he had no conversation. There is nothing on the record that says that Mr. Upcraft then reached out to Bank of Utica prior to Bank of Utica, A, terminating the relationship with Peters, and then B, Bank of Utica then approached Mr. Upcraft. And I think that the Bessemer case clearly states that Mr. Upcraft is allowed to respond to inquiries from a prior client. He's just not allowed to initiate them, nor is he allowed to pursue them. Here, Bank of Utica pursued him. He was free under Bessemer, which modified Mohawk to accept employment.
I think we have your argument, Counsel.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Corey Schoonmaker from Sugarman Law Firm on behalf of the respondent, Peters and Associates. The Supreme Court correctly concluded that, one, the common law duty that we've been discussing applied to Mr. Upcraft, and two, that the course of conduct between his termination by Peters and Associates and his hiring at the Bank of Utica raised a question of fact as to whether or not he violated that duty. With respect to the first point that we sort of only touched briefly on, I will just rest on my papers for the purposes of the preservation argument. The Court is well versed in preservation and can sort out whether or not and to what extent these arguments were previously raised. But I would like to distinguish the MGM and CSI decisions. We recognize that this common law duty, like many common law duties, can be expressly limited by contractual agreement. That is not what we have here. In both MGM and CSI, the limitations they were talking about were limitations to the specific party or the specific customers that could be solicited, or the period of time. The common law duty being infinite in duration, the period of time limitation made sense in that context. And in those cases, the customers at issue either were or were not outside the list of customers that could be solicited. That was the basis on which MGM and CSI found that the common law duty had been limited. That's not what we have here. Instead, the argument that is being raised is that there's a difference between the going out on your own and getting this, doing this solicitation for your own benefit as opposed to for a future employer. Our position is that, as with all contractual agreements, the court should look at the intent of the parties. Obviously, in MGM and CSI, the parties intended to limit the non-solicitation obligations to specific clients. That was part of the bargain. Here, what happened was not, in our position, a reasonably foreseeable outcome that Mr. Upcraft would stop working for a CPA firm and instead take a job as a CPA, sort of like an in-house attorney for a specific customer of Peters and Associates. It wasn't, there's no evidence that it was something that was contemplated during negotiations, and the plain language of the contract doesn't suggest that. So our position with respect to the first point is simply that even if the arguments being raised have been preserved, the contractual language cited does not extinguish the common law duty. Now, under the common law duty, the court correctly found...
Counsel, let me kind of ask you, your opponent is saying there was no, I believe, is that there was no solicitation, that he was solicited. Does that make a difference?
Not in this case, Your Honor.
Why?
The Bessemer case discusses that not only can Bessemer really sets out a lot of examples of the types of permissible and impermissible communications. It isn't limited to calling up a former customer and saying, I would like your business. It also includes touting one's new business business ventures. For example, just so you know, I'm not asking for your business, but I'm on the job market right now. It also includes conversations initiated by the customer that the employee.
So what do we know about the conversation that transpired here that was violative?
Well, we know very little about what in fact was said. What Supreme Court found was that they didn't expressly say, the court did not expressly use the term circumstantial evidence, but reading page 14 of the record, or page of the decision, reveals that that's the analysis that was being done here. The court emphasized communications between defendant and the bank as to the employment status of defendant, and that very shortly thereafter, the bank chose to terminate this relationship, and then I think it was within, the evidence was a bit unclear, it was somewhere within a few weeks, maybe 1 week, maybe 2 weeks, between terminating Peters and Associates and hiring Mr. Upcraft. That conspicuous timing was what the Supreme Court concluded raised a question of fact. Now, because this motion was defendant's motion, it was defendant's burden, as the court knows, to eliminate these questions of fact. The only other person who could corroborate what was said during these conversations, and as I will note in a second, there were multiple conversations testified to, was Tom Sinott, the president of the Bank of Utica, who is, I believe, still the president of the Bank of Utica and arguably would be accessible to either of us. In the reply papers, the defendant has pointed out that we never deposed him. But it's defendant's burden on the motion to submit the evidence that would eliminate the questions of fact. The question of fact here existed on the face of their motion and in the documents already before the court because of this conspicuous timeline and the conversations in which he admitted that he talked about his employment status.
Wouldn't it, if you're no longer working for Peters and you serve as a client, wouldn't you have to call and say, hey, wouldn't there have to be some communication? I'm not doing this job anymore. You just don't not ever return phone calls and don't explain why.
Yes, Your Honor. So in this instance, Mr. Upcraft was terminated effective immediately. I believe there was some language that he was called while Mr. Peters was out on vacation out of state, and he said, you're fired. And at that point, he no longer was a Peters employee. If anyone had an obligation to speak to this client about who would be handling their file, it was Peters, not Mr. Upcraft. Mr. Upcraft called a former client of his that he'd been working for directly since 2000, both from Warren Hart and then for Peters and Associates, said, just so you know, someone of Peters will be in contact but I'm not working for them anymore. And that length of relationship, the loyalty that existed between the Bank of Utica and Mr. Upcraft personally, combined with the timing of what happened in that autumn of 2018, is, I believe, sufficient when the evidence is viewed in the light most favorable to Peters and Associates to raise a question of fact. Now, any issue with how many conversations were had, the testimony was a bit ambiguous, but I believe on 284 to 285 of the record, if I have my site correct, there was testimony that there was a back and forth different times discussing something, we don't know exactly what was said on these conversations, between Mr. Upcraft, who was then not an employee of Peters, and the bank. I think that on its face raises yet another question of fact that would preclude summary.
Counsel, you should begin to wrap up.
If there are not any further questions, Your Honor, I was just about to.
Very good. Thank you, Counsel. Case 1046 through 1050, JP Oil Group, Inc. versus Lakhani.
Good afternoon, Your Honor.
Hold on a second. We got to wait for counsel to appear on video. Counsel, can you hear us? You need to unmute.
Yes, I can.
And we can hear you. Okay, very good. We'll proceed with the argument. Proceed.
Good morning, Your Honors. Mo Atari of Atari Associates. On behalf of the appellant, may it please the court. The lower court here granted summary judgment to the petitioner, and there's a lot of issues here that require an addressment by this court. First, the complaint only sought judgment interest. The court granted prejudgment interest. Second, the minimum purchase obligation was much lower than the actual purchase obligation. Third, the doctrine of oral modification allowed verbal alteration, and I cited the cases of Lusker and NASA for that. Fourth, the signed estoppel certificate was an acknowledgement of a lack of default by the respondent. Fifth, the liquidated damages was only for the remaining term of this agreement, and the lower court found ongoing damages. And sixth, the unpaid fuel charges were all subsequent to the acknowledged July 2019 acknowledgement by opposing counsel that they were aware of the situation. So based on all of those facts, I'd just like to address a couple things that the respondent put in his papers. One point he discussed was the renewal of the motions, and clearly the court in its decision says that it reviewing the parties' submissions, including all items in NICEF, and that the court ordered that any further papers directed to seek renewal of the motions must be submitted for further argument. So the court was fully aware of what it was doing, and so based on those points, I think there's clearly questions of fact all over this record.
Any further, counsel?
That's all.
Very good. Thank you. Counsel, proceed.
Yes, thank you, Your Honors. First of all, the motion for summary judgment specifically sought prejudgment interest. That's at record 245. So did the moving affidavit of the principal, Mr. Tile, record 269. Perhaps most important, defendants raised this argument only in their reply brief. And the law is clear that you can't raise an argument for the first time in the reply brief. The matter of Clairol Development, 100 AD 3rd at 1547 is just one of many cases in which this court, as well as other courts, made that clear. The minimum purchase requirement, I think plaintiffs, defendants have that confused. There was a minimum purchase requirement, which was set forth in the declaration, the base page of the dealer sales agreement. And it was stated, however, that if it would be a default if in a month the purchases fell below 80%. It's interesting that on page 22 of defendant's appellate brief, they admit the default. They admit that they almost always fell below that 80%. Nevertheless, the 80% was a trigger of default, which was triggered, as they admit on page 22, but it doesn't change the minimum as set forth in the bill of sales agreement. There's no reference, there's no conduct that's unequivocally referable to an oral modification. And I would add that this oral modification argument, which is supported by no evidence, no conduct by my client that would support such a verbal modification, that to support it. For example, defendants make the point that we could have amended the agreement. We could have. We didn't. There's no evidence that that happened. The estoppel certificate was not signed by J.P. Orr. Furthermore, it was not signed by anyone other than, let me rephrase that. It was not a representation made by anyone other than the defendants. The estoppel certificate is a representation made by the defendants, and no one else, to the bank that was helping to finance the purchaser of the property. And I would add, purchase of the property from an entity other than my client. Liquidated damages, that's an argument that I think is wrong on the merits, but in addition, that's not an argument that appeared anywhere in the trial court. For example, Mr. Attari's February 28 letter basically said there was no breach up to the point when the tanks were taken out of the ground in September of 2019. That was not true. And in fact, they admitted it on page 22 of their brief. They had never purchased everything that they were supposed to purchase. They had almost always been under the 80% minimum purchase requirement that would trigger a default. He doesn't raise it at the trial court. He raises it for the first time on appeal. And you can't do that. And Clearwell Development and the Henry versus New Jersey Transit, 39 New York 3rd at 367. And there's a reason for that, because the re-argument renewal was a very narrow one. The trial court, based upon the evidence and the record that was before it at the time, which did not raise any issue of fact as to any defense, basically said, we've got two issues of fact, and I'm going to put them down for a bench trial. One issue of fact is, was the Department of Environmental Conservation order, was that something that excused further performance? The other was, will we give a notice of that, which was a requirement in order to trigger an exclusion? And I thought, and this was a decision that we made, we're going to answer those two questions.
Right, counsel, just to cut to this quickly, you just reduced your $500,000 demand to $220,000.
Right.
In order to resolve those questions of fact, you cut off the damages, the liquidated damages at the time the deed.
And had I not done that, I might have lost. I'm sorry, go ahead.
Well, that's your point. You eliminated any questions of fact by reducing your demand here. You terminated your losses underneath the liquidated damages provision.
Right, going forward, that's correct. And the reason why I might have won that, I might have lost that. If I'd won it, yeah, it would have been $500,000.
And the court was and to finish, the court was very careful in calculating limited damages up until that date. In fact, did some of its own computations.
Correct, and cut me down a little bit more, that's right. And the point there was, Your Honor, we didn't want to prolong it. We didn't want it to drag it on. These are narrow issues. We can answer them. We can avoid the risk of a trial. We can avoid the expense. My client is very pleased with the judgment that we have. We respectfully ask the court to affirm it.
Thank you, counsel.
Thank you, Your Honor.
Case 1050.1 and 1050.2, Bruce Smith versus Triple O Mechanical, Inc. And we're waiting for Mr. Basinski.
Okay.
Counsel, can you hear us?
Good morning, Your Honors. Yes, I can hear you fine. Thanks.
And we can hear you also. Please proceed, counsel.
Thank you. Good afternoon, Your Honors. May it please the court. David Tang on behalf of the defendant appellants. I think this case presents something in the nature of a procedural pretzel, at least based on the decisions made in the summer of 2023. There is a discovery motion, there's a cross motion for 3212 relief, and then there's a decision that's made on the eve of the lower court transferring the case to a new judge. I believe the pretzel can be straightened out, though, by focusing on the question of should the briefing schedule under 2214B have been enlarged, and we submit that it should not. The briefing touches on the discretion of the court to control its calendar. The court can and does have discretion, but the discretion is not unlimited. CPLR 2004 provides that a court may ignore time periods fixed by statute upon good cause shown. No such good cause here was established by the respondent, and we respectfully submit that it was error to hold in abeyance the cross motion seeking dismissal relief that was made in direct response to the discovery motion to compel, with both motions returnable on the same date. In opposition, respondents have suggested that this court has raised a justiciability argument, that this court may not proceed when a motion has been held in abeyance. We have submitted Cena versus Nationwide from 1993, and the Second Department tells us that, quote, a notice of appeal may be treated as an application for leave to appeal, which may be granted in the interest of justice. We ask that the court do that here. Cena supports that this court can look to the record, can look at specifically and importantly the cross motion papers, confirm that there was a return date for both the underlying motion and the cross motion on June 21st. There was no agreement, no directive, no stipulation to change the return date on the 21st, and that this court can search the record and make a decision on both motions, which should be decided together. With respect to the June 21st date, I think it's important to pay attention to this control and return date. The subject discovery motion was returnable June 21st, 2023. This was on consent and agreement of the parties. See the record, please, at page 464, memorializing that agreement. The agreement with respect to the return date of June 21st was communicated to Genesee Supreme. That's also acknowledged in the record. The cross motion in opposition to the discovery motion was timely served June 5th, returnable on June 21st. The cross motion is directly applicable to the discovery motion. If the dismissal is granted, discovery on further claims of the plaintiff are moot. The parties never stipulated to adjourn the return date prior to June 21st. The court never communicated to the parties that there would be an adjustment of the return date prior to June 21st. In short, the return date for both motions stands on the 21st, and the court has, from our perspective, abused its discretion to rule on one and not both of the motions when they are intertwined. We submit this court can treat the notice of appeal as our leave to appeal. We're asking the court to study the record carefully.
We understand that request, counsel.
If I just can touch on it briefly, there has been some discussion with respect to the release that was given by Mr. Smith, plaintiff, the former employee, perhaps disgruntled, of the appellant's company. It's an important factor as part of the record where the March 29 release, the plaintiff agrees to, quote, forfeit any future legal action to be taken and release all claims as between himself and the appellants. The cross motion returnable on the 21st incorporates the release. It seeks dismissal of the claims that have been released. We ask the court, in looking at the record, find the release applies, is valid. There were opportunities for plaintiff respondents to oppose the motion. There were opportunities for them to brief prior to June 21st. There was an opportunity for them to request, consistent with Rule 2028E, an enlargement of the briefing schedule. None of that was done. And so we're asking for ruling based on what we submit as a fully briefed cross-motion record. Thank you.
Very good. Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the court, Ryan Lusinski for the respondent, Bruce Smith. I'm confused as to how the release is part of the record. It's part of the appellant's summary judgment record. I think case law is very clear that where a court decides to hold a motion in abeyance and it's undecided, it's not fully briefed, it hasn't been argued, it's been set for argument tentatively into Q1 2024 by the current trial court justice, that this is not ripe for decision by this court, by this panel. We have no real authority in opposition to that point. I think, frankly, that the appellant's opening brief spends the majority of their time and ink arguing summary judgment. This is a discovery appeal on discovery orders. This was brought by the appellants by order to show cause with respect to the discovery orders issued by Justice Walker. And you don't really have any argument as to the standards and the merits of the discovery issues that were decided. You have appellants arguing summary judgment. And I think that it's not properly before the court, and all of those arguments and the record that was proposed or put together by appellants with respect to summary judgment should be disregarded and allowed to proceed at the lower court first before it can be reviewed and or decided by this panel. Probably will be later. With respect to the orders themselves, Your Honor, I think it's important to know how intimately involved the trial court justice was with this proceeding, specifically with this dispute. There was significant pre-answer motion practice with respect to the dismissal of a complaint, which, by the way, appellants never raised this release, which is curious. There was motions to quash subpoenas on the non-parties that would have had these records. There was obviously the motion to compel. There were a detailed conferral process. There was deficiency letters. There was experts retained submissions to the court. There was a lot of history where Justice Walker and his then law clerk, Darrell Colosi, presided over with due attention as to what was transpiring between the parties, the behavior of the litigants, the outstanding and length of the protracted delay and dilatory tactics of the appellants, and to what we were ultimately entitled to by way of records. There really is there's no case law that's been provided or other authority that contradicts the fact that Justice Walker and trial courts have inherently broad authority to control their courtroom, their calendars, supervise discovery, and decide as they see fit, even sua sponte. We've provided those cases for Your Honors. And he decided, as he did here, with numerous chances to explain himself in light of appellant's counsel's questions and prodding. That's in the record. I would ask the courts to review the reasoning that is attached to both orders at pages 8 and 9 of the record. I believe the stay order is page 22 of the record, where Justice Walker explains that how respondent plaintiff has filed or followed every direction of the court to the letter, and that these are routine discovery demands. This is routine information in light of the fraud and contract claims at issue, and that frankly the court was somewhat dismayed that they couldn't be worked out between the parties because it is material necessary. This is the course of 18 months, Your Honor. They move at the 11th hour right before Justice Walker is going to come off the bench. So of course we asked for a conference, an emergency conference, to discuss the briefing and how the court wanted to handle the competing motions. The court on its own said no conference necessary. Here's our decisions. And so I'm not sure how CPLR 2004 applies with respect to the court and the fact that it's managing its schedule accordingly. The motion to compel.
We'll take a look at that, counsel. Is there anything further?
Your Honors, I appreciate your time and attention. Thank you.
Thank you.